Hello friends, in the series on the income tax cases, today we will discuss a very important issue which is in regard to section 153C proceedings. The very limited issue before Kolkata ITAT-C bench in the present case was that in case of other assessee, meaning thereby that on whom there is no search but some material has been found related to that assessee in the search of another person. So in that case, what date should be treated as date of search, whether it is the actual date of search or whether it is the date on which the assessing officer of the searched assessee handovers the material to the assessing officer of the other assessee. This issue has been taken up by Kolkata ITAT-C bench in the case of Assistant Commissioner of Income Tax versus Jaideep Halwasia. This case is reported in 122 ITR Tribunal, short notes 52, and the date of the judgment is 13th February 2025. In the present case, there was a search on Assessee A on 6th February 2019. The assessing officer of the searched assessee recorded a satisfaction note that some income has escaped in case of other assessee also, so he handed over the relevant material to the assessing officer of the other assessee for the assessment under section 153C on 26th September 2022. When this material was received by the assessing officer of the other assessee, the assessing officer of the other assessee issued notice under section 153C to the assessee and completed the assessment by making addition by disallowing the loss on the basis of some reversal trades. It was the allegation of the AO that these are bogus transactions. The assessee challenged this assessment under section 153C before the CIT appeal. One of the ground of the assessee was that the addition has not been done in reference to the incriminating material. And the second contention of the assessee was that the assessment is related to the assessment year 15-16, and since the handing over of the material was done on 26th September 2022, so according to that, if the 6 years are counted according to proviso to section 153C and according to the amendment in section 153C, so the maximum period for which the AO can go back was assessment year 17-18, so the notice is time barred. When the CIT appeal heard the appeal of the assessee, the CIT appeal was with the assessee on the ground that the addition has not been done in reference to the incriminating material, so he deleted the addition on that ground, but he was not convinced with the assessee that the date of the search is to be taken for that date on which the handing over of the material has been done. When the matter was before the tribunal, because the revenue filed the appeal against the order of the CIT appeal, the tribunal said that in the present case, the CIT appeal has misinterpreted section 153C. According to proviso to section 153C, the date of search is to be treated as the date of handing over of the material. Since in the present case, the handing of the material has been done on 26th September 2022, so the maximum period which can be covered for section 153C proceedings in the case of the assessee was from assessment year 17-18. Since in the present case, the assessment has been done for the assessment year 15-16, so that period is not covered under section 153C proceedings, and the notice and the consequent assessment is bad in law. Friends, this case is very important because in section 153C proceedings, the department very casually counts the number of the years for which the section 153C proceedings can be counted, relying upon the date of search, which is the actual date of search. But in case of other assessee, the date of handing over of the material is to be treated as the date of the search, and 6 year period should be calculated from that date. So in the present case, the tribunal allowed the ground of the assessee that the notice and the assessment is time barred. At the end of this video, once again I am repeating the name of the case. The name of the case is Assistant Commissioner of Income Tax versus Jaideep Halwasia, and this case is reported in 122 ITR Tribunal, short notes 52, and the date of the judgment is 13th February 2025.